Okay, let's get started. First, I would like to ask everyone to please mute themselves and switch your view from gallery to speaker. If you're not sure how to do that, the team will add some direction in the chat box. Hello, everyone, and welcome to NJBIA's Human Resource Council meeting, Workplace 2022, Managing Employee Leave and Legal Implications of Remote Work in the COVID-19 Era, brought to you by NJM Insurance Group, Investors Bank, Connell Foley, Prime Point, HRMS, and Payroll Association Member Trust, and the NJBIA HR Support Center. My name is Keith MacDonald, and I serve as the Regional Sales Manager with Prime Point. And with us today is Michael Shadiack, Chair of Connell Foley's Labor and Employment Practice Group. Before we get started, we want to show you a quick video on some of the things NJBIA has been working on recently.
Your business pulls you in a lot of different directions. Managing HR is just one of them. What if you had a team to turn to that could take the guesswork out of HR, save you time by researching the answers for you, and help protect your business? Don't worry, we've got this. With the all-new HR Support Center, we offer in-depth advice and insights you can't find anywhere else. Plus, with HR On Demand, get live unlimited consulting with our team of certified HR pros, HR experts who are easy to talk to and are ready to help. Get ready to experience HR in an entirely new way with the HR Support Center and HR On Demand.
Today's presentation is being recorded and will be emailed to you tomorrow along with the PowerPoint, so please be on the lookout for those. I'd also like to draw your attention to the chat box. Mike would be happy to take your questions, so get them in as they come to you via the chat section, and we'll answer those after the presentation. And then after today's presentation, we will have 15 minutes to network with the speaker. As I mentioned before, my name is Keith MacDonald. I'm the Regional Sales Manager for Prime Point. Prime Point is a payroll processing and human resource management company offering a fully integrated suite of technology tools. The company addresses the needs of small, mid-sized, and large business and is capable of serving companies with 1 employee to 10,000 or more employees. One of Prime Point's major differentiators is the company's willingness and capability to customize the software configuration, which creates unique solutions to meet the needs of individual businesses. Prime Point also takes a different approach to customer service that starts during the sales process and continues through to everyday ongoing operations. We call this the Prime Point experience. To learn more, please go to primepoint.com. As Affinity Partner of the NJBIA, we're offering all members discounts on our services. To learn more, please go to njbia.org/primepoint. If you'd like more information or a quote, please enter your information at the bottom of that webpage and I'll reach out to you. And now it's my pleasure to introduce our speaker. Michael Shadiack is a partner in and chair of the Labor and Employment Law Group at Connell Foley, LLP in Roseland, New Jersey. Michael has devoted his entire 24-year legal career to practicing labor and employment law on behalf of employers. Recognized for his in-depth knowledge of employment law as well as his responsiveness and approachability, Michael provides employers with proactive and preventive strategic counseling on personnel issues to ensure compliance with federal and state labor employment laws. He also prepares comprehensive and practical employment agreements and employee handbooks that are tailored to each employer's specific needs. In addition, Michael defends employers in litigation in state and federal courts and before state and federal administrative agencies. The author of numerous articles and professional materials, Michael regularly presents nationally and regionally on traditional and cutting-edge employment law topics and conducts practical employment law training programs for employers to educate their managers. For multiple years, Michael has been selected for inclusion in Best Lawyers in America and New Jersey Super Lawyers, and honored as a top 10 employment law attorney by Mars, Essex, Health and Life. So now, without further ado, Mike, take us away.
Great. Thank you, Keith. Good morning, everybody. It's so great to be here. I do appreciate your time and joining us today. I'd like to share my screen so I can bring up the PowerPoint. Okay, so we're ready to go. So as Keith mentioned, I do appreciate that introduction. My name is Mike Shadiack. I am the chair of our employment group here at Connell, Foley, and I'm based in our Roseland, New Jersey office. And my practice is really devoted to assisting, supporting, representing employers and their management with all their personnel issues. And two of the topics that are really hot these days, and we're getting a lot of phone calls and emails about, are what I'm going to be talking about today. Remote workers, and also managing employee leaves of absence. I find that managing employee leaves of absence is one of those things that a lot of employers struggle with. Even experienced HR professionals often struggle with. And so we wanted to do a program today addressing both of those topics. So you're going to get the PowerPoint, and we have a lot of information to cover today. So that's why we ask that you hold your questions to the end. So let's talk about our agenda. We'll talk about remote workers from a wage and hour perspective, policies, and also return to work considerations. And then how do we manage leaves of absence, but also understand income replacement benefits and how that factors in to an employee's leave. So let's start with the wage and hour considerations with remote workers. So first, I want to talk about your non-exempt employees. Okay, and just real fast as a recap, what is a non-exempt employee? Well, that's someone under the Fair Labor Standards Act and New Jersey law that is entitled to earn overtime. So in other words, how do you become exempt? Well, to be exempt, you have to be paid on a salary basis over roughly $36,500 a year. And your duties fall under one of the stated exemptions under federal and state law. And that's really a discussion for another program, and we'll be doing one for everyone later this year. But non-exempt employees are those entitled to overtime. Now remember, when you're dealing with your remote workforce, the same wage and hour laws apply as if they're working in the office. And a mistake that I've seen a lot of employers make during the pandemic is not tracking the hours worked by their non-exempt employees when they're working remotely. It is just as critical as when they're in the office, just as critical. And the reason is, if there was ever a challenge by an employee to say, wait a minute, you did not pay me for all the hours I worked. You didn't pay me for the overtime that I worked. If there are no records of the hours the person's worked, there is a rebuttable presumption that the employee is correct. What the employee is alleging is true. And the employer is going to have to demonstrate why it doesn't have these records, how it could prove or disprove the hours that the employee worked or didn't work. And it's really not clean. It's not crisp. And any presumption is going to weigh in the favor of the employee. So please, with your remote workers, make sure there's some way in which they are recording their hours worked back to the office, and that those records are being preserved. And remember, they have to be preserved for 7 years, not just 1 year or a few months. We have to be preserving those records for 7 years. And this is particularly important when it comes to meal and rest periods. We all know when people are working remotely, it's not as structured of a day as when they're in the office. So are they really taking that half-hour unpaid meal period? Are they really taking those unpaid breaks throughout the day, or are they continuing to work? Because if they're continuing to work, they have to be paid for that time. So you want to have policies in place. You want to reinforce that they have to use their break time, account for that time on their timesheets, or by logging in or out, however you determine that. Whatever system you have in place for your employees, make sure they're adhering to that. Very important. If you have an employee who just works right through their lunch every day, well, think about it. If that's a half hour every day times 5, okay, that's going to be hours worked. And now if that puts them over 40 in the week, that's overtime. So please be very mindful of that. So we have here on the next bullet point, overtime. That's all hours that the employees are suffered or permitted to work. So let's take a look at that. Your non-exempt employees must receive 1.5 times their regular rate of pay for all hours worked over 40 in a work week. And each work week stands alone. That's another common error I find employers make. They'll look at it as, well, we have a 2-week pay period, so we're going to look at every 2-week block and determine who's owed overtime. That's not the legal standard. Every week stands alone, so you have to see, did they work over 40 hours in that week? And if so, they're due overtime. Now, you say, well, what about comp time? Can we just give them comp time, time off in the future, in lieu of overtime? The answer is no. Under New Jersey law and under federal law, if the employee who's non-exempt works more than 40 hours in the week, they do get paid time and a half. Could you make some adjustments within the same pay period? Yes. So if you see the employee has basically hit their 40-hour mark by Thursday, maybe you tell them, don't come in tomorrow. All right, we'll give you the day off. You want to keep it within that 40-hour. Within the same pay period is fine. You can't bleed over into that next week of work. Okay, non-exempt employees with supervisory permission can have flexibility, as I say, to work within that same pay period only. Very important. Now, what about your exempt employees? Well, exempt employees must be paid for the entire work week if they perform any work in that week. Any work in that week, they get paid for the full week. That's part of being exempt. Now, are certain deductions permissible from an exempt employee's pay? Yes. Purely personal reasons, if they're on FMLA leave, which we'll talk about in just a few minutes, and their first week and last week of work. They only work Monday and Tuesday, and then they quit, or that's their last day, they don't get paid for that full last week. Okay, so those are some of the limited exceptions. What I would suggest to everybody, if you want to learn more about this, it's called the salary basis test under the federal law, Fair Labor Standards Act. And a really nice snapshot for you to get more information is if you Google FLSA Fact Sheet 17G, as in girl. It's about a 2 or 3 page fact sheet issued by the Department of Labor. Very helpful, very practical information. And that will let you know what can we deduct from an exempt employee's pay. The general rule of thumb, as I say at the bottom, if the employee is not working due to their own decision, a purely personal reason, it's possible the deduction is going to be permitted. But if the person's not working due to the employer's direction or some operating requirement, the deduction is not going to be permitted. So worth it, I think, for everybody to take a few minutes, grab that fact sheet off of the Department of Labor's website and take a look at it. Now, here's an issue we fielded a lot of calls on of late and is often overlooked by employers. So let's say you have employees that are going to work remotely, but they're working remotely out of state, either temporarily because of COVID or permanently. Well, I don't like the word permanently, but on a continuous basis. Okay, you're a New Jersey employer, but guess what? We're going to hire a new person out of Arizona, and that's where they live and that's where they work. Employers aren't now taking that to the next thought of, what about the tax consequences? Do we have to withhold payroll taxes for that individual who's working out of state? Do we have to register to do business in that other state? These are very important questions. Most often than not, the answer is going to be yes, as to both of those questions. What I suggest, speak with your tax professional about that. Reach out to your company's accountant. Really, this is a payroll tax question, and the laws under the IRS guidelines are very tricky to understand. And I would venture to say employers probably don't want to dabble in it and try to figure this out themselves. You want to speak with your tax professional. Find out, hey, we have workers in Montana, New York, Florida. Do we have to register to do business in that state? And do we have to withhold payroll taxes? Now, some states apply what's called the convenience rule. That is, if the employee is living and working remotely in another state for their convenience, okay, are the taxes withheld or not? Or is the employer working out of state at the employer's direction? That's a standard that a lot of states will apply, and every state uses a different standard. New Jersey looks to where are the employee's services actually performed. And if those services are performed in New Jersey, okay, New Jersey withholding is going to be taken out of that employee's pay. Very tricky, very subtle issues. Again, I can't reinforce enough. Please take the time, speak with your tax professional to get the guidance that's specific to your company and the location of your remote workers. Let's talk a little bit now about a policy that you want to have in place for your folks that are working remotely. Also a home, what I call location safety checklist, and then return to workplace considerations when that time comes. So your telecommuting policy. Employers may wish to adopt a flexible telecommuting policy that's going to complement your phased-in return to work plan, especially related to COVID. Or maybe you have employees whose their children are virtually learning and you're accommodating them or giving them a courtesy to work remotely during that time. So now we want to have a telecommuting policy in place that addresses what are the rules when they're working remotely. Well, here's the one that I think is at the top of all employers' lists that we've spoken with. Reinforce the importance of safeguarding confidential business information as well as your confidential customers' information, including from members of their own household. Remember, they're working now remotely. All those work files are on their desk or on their computer. How do you know who can see those documents, who could see the person's computer screen? When they're working in the office, you can ensure to the best you can confidentiality. But now they're at home. How do you know who's seeing that? How do you know your employee's spouse or significant other doesn't work for a competitor and now is having access to confidential information on the computer? They're seeing emails. How do you know that the person's neighbor or friend doesn't pop over for a visit and all the work documentation is now exposed? Right? That's a very significant issue. I know with our firm, we're taking that very seriously. Not only our firm's confidential information, but think of all our clients' confidential information that's in the hands of our lawyers working remotely. We have very, very firm and strict policies here in the firm to safeguard that information. You should as well. That's my recommendation. You want to require your employees to utilize up-to-date antiviral software. Make sure their virus definitions are up to date. They're running regular scans to make sure everything is up to date and secure. You also, I would say, train your workforce on cybersecurity issues, the importance of it, what phishing is, phishing emails that they may receive, what social engineering materials look like, how to avoid falling prey to someone who's trying to trick you when working remotely. Very important. I know our firm, we have a whole cybersecurity team, and they're constantly doing training for our clients on this very important issue, including for our own firm, because you have to know these things. One little click could be devastating. Ensure the employee has adequate internet capability and the necessary IT equipment to do their job. You can't imagine how many phone calls we get where the person's going to work remotely and they don't have what they need, right? You have to make sure, work with your IT professionals and make sure not only what they're using is appropriate, but is properly safeguarded. Address who is responsible for these costs of internet service, data plans, the electricity. Think about it. Your employees are now working remotely. Their costs are going to go up. What if they don't have an adequate internet connection and have to upgrade to a higher bandwidth? Who's going to pay for that? The employee expected to pay for that? Is the company going to cover that expense? Well, that's really a company decision, but it should be discussed. It shouldn't be left unknown, or for the employee to just expect that the company will be incurring and reimbursing them for those charges. All right. Reserve management's rights to conduct what I would say an audit to make sure that your confidential information is protected, that they're using the proper IT equipment, that their virus definitions are up to date. A member of your IT team, send them to the employee's workplace, of course, with proper masking and equipment, PPE, but to reserve that company's right to do that. You don't want to just take the employee at their word that they have everything in order. How about your employees' accessibility? Right? You send them an email, you call them on the phone, you leave them a voice message. You're expecting a return call or return email promptly. Okay, how promptly? Is the next day appropriate? Do you want to hear back within the next hour, the next 2 hours? Hold them accountable. It's not acceptable to say, well, I was working remotely and I didn't get your email, so I'm calling you back 4 days later. That wouldn't be acceptable in the workplace if they were in the office. So have standards in place. Hold individuals accountable. Right? When do phone calls or emails have to be responded to? And reserve the employer's right to discontinue the telecommuting arrangement at any time. Very important. This is not forever and ever. A couple other things. We talked about overtime. Make clear that working more than 40 hours in a work week by a non-exempt employee without written permission is not acceptable. Okay? We can't just say, well, you know what, I'm going to watch the Super Bowl and I'm just going to keep working because my computer's here and I'll have it on my lap and I'll just keep working and guess what, I'll earn overtime. That's not acceptable. Right? They have to get permission, make sure management's aware that this overtime is being worked. Now, I often suggest to our clients, require your employees to create and maintain a safe off-site working environment. Report any work-related injury that occurs while working remotely. You may say, well, how do we do that? How could we be so sure? Well, one tool to use is what I call an off-site work location safety checklist. It's a document. And in that document, we're going to have a number of areas that we want to make sure the employee is monitoring, ensuring is in place, and then we'll check off in this document and sign and certify that they have actually done these things and they are presenting a safe workplace for themselves while working remotely. It's important. Think about it. If an employee were to trip over a cord, you see the picture I have at the beginning of the slide, right? They have cords running across their floor and they get up and they fall, right? And they get hurt. Well, that happened during working time. Now we have to address a leave issue, and it's potentially going to be a workers' compensation situation. How do you defend that workers' comp situation? Well, it's kind of hard, but if you have a policy in place, if you have this checklist in place, if the employee has stated, I'm presenting a workplace that's safe, I'm certifying to all these things, right? But the employee goes outside of that, maybe the employee is negligent themselves, it may provide your company an opportunity to have a defense in that type of claim. Okay? It's all about the employee safety, don't get me wrong, but it's also about protecting the company. So I just listed some things here that I pull out of the checklist that I prepare for our clients. And not to go through all of them, but again, that their floors and their workspace are clear from any tripping hazards. Their file drawers are not top heavy. They're not going to fall over while they're sitting at their desk. Phone lines, electrical cords are secured under their desk along the wall. All right, they're not next to a heating source. Carpets are well secured to the floor. They're not frayed. They're not worn. Okay. Make sure you're using a surge protector. If they're going to have a printer and a computer and a fax machine and some other things, you don't want them overloading their electrical outlet. Simple things like this. But these are all important safety concerns. So you would have a document, you have the employee sign off and turn it in. To me, I think it's a very good tool for employers to use. Now, we get to the point where we want employees to return to the workforce, whenever that may be. Maybe when there's a clearing up, hopefully, of the virus and folks can come back to the workplace and feel comfortable doing so. You may want them to come back. And I just wanted to list a few practical considerations for bringing employees back to the workplace. So let's say your employees are afraid. They're afraid to come back. They've been working remotely now for some of them 2 years. They're afraid of the unknown. They're afraid of what steps have you as the employer taken to present a safe workplace for me? How do I know I'm going to be safe and secure? I just don't want to leave my home. So a couple practical thoughts. Number one, find out why they're concerned. What is their fear? What are they not sure of? Keep an open mind and listen to what their concerns may be. Then you want to inform your employee about the steps you have taken to create a safe workplace. Reassure them. Share your company's COVID policies. By now, every company should have a COVID policy that's dealing with how are you working to contain the virus? What steps are you taking to have personal protective equipment, to enforce social distancing? What are you doing in the workplace to make it as safe as possible? How about travel? What is your policy on travel? And quarantining before or after you return? Are you allowing travel? What is your standard on travel? What is your policy on vaccination? What is your policy on face coverings in the workplace? You want to have these in place and share them with your employees so they understand you're a responsible employer. You've taken the necessary steps to create as safe a workplace as possible. Explore if remote work remains an option for the company in their particular position. It may not. Now, does the employee, do they have an underlying medical condition? Is that why they're concerned? Is that why they don't want to take a risk coming back to work? Well, if this person is in a higher risk category as determined by the CDC and the Equal Employment Opportunity Commission, you're going to have to really think about that and engage in the interactive process to determine, can we accommodate this worker? Can we help them? What are some accommodations, if any, to allow them to perform their job and to do so in a safe manner? Do we have to continue to offer remote work to this individual if they're in a high risk category? Very fact sensitive. It's an employee by employee analysis, and you have to engage in that dialogue, that interactive process with that employee, along with securing the information from the employee's doctor. And we'll talk about that in just a minute. Now, if the person's not in a high risk category, then what are they really asking for? I'm afraid. I don't want to come back. Do you have a medical issue? No, I'm just afraid. I haven't left my house in 2 years. I don't even go to do food shopping. I have it delivered to my home. I'm just afraid. Okay? That's not going to be something that needs to be accommodated under the law. Really, what the person's asking for is a business courtesy. And how will you handle that courtesy? And be mindful, if you're going to grant a courtesy to one employee, that you're not doing it in a way that's discriminatory toward others. So if you grant a courtesy to one employee, but you don't grant a courtesy to another, are we potentially inviting a discrimination claim? Something to think about. I know we want to be nice. I know we want to grant courtesies. We want people to get the work done and feel comfortable, but we also have to keep the legal standards in mind and not put the company at risk just by doing somebody a favor. So something to think about. What if that employee is caring for his or her child whose school or place of childcare may close temporarily due to COVID? Maybe there's a spike in their school and the school closes down for a period of time. Well, we're going to want to determine if that employee maybe is eligible for leave under the New Jersey FMLA Leave Act. And that's just a little teaser. We're going to get back to that in a few minutes when we talk about the NJFLA, but it's something to consider. And if after exploring the above, the employee still refuses to return to work, then that employee may be considered to have abandoned their position. Is that a tough management decision to have to make? Sure it is. But it's something that may become a reality for many employers if folks just will not return to the workplace. So hopefully those tips there were helpful in addressing remote workers and also when we're potentially bringing them back to the workplace. What I want to spend the balance of our time on, because it's a very large topic, is managing leaves of absence and understanding income replacement benefits while an employee is on leave. And this is as to all of your employees in the office, but also your remote workers who may need a leave of absence. Now, I do a lot of training for our clients where I'll go on site or do it virtually. And one of the topics we train management on is this exact topic, managing leaves of absence, understanding income replacement benefits. And that training is typically about 2 hours long. So I'm going to be taking the material for that training, and I'm going to be summarizing it in a bit so that we can address it here in about the next 45 minutes. And then we can open it up to questions. Now, here is the slide that I hope sticks with everybody. If all the slides, if any of these slides really resonate and stick in your mind and is something that you remember after this program and beyond, remember this slide, remember this visual. are we talking about leave or are we talking about an income replacement benefit? And think of the two railroad tracks. Why? Because they're two totally different concepts. Notice the railroad tracks are not intersecting. They're two separate concepts. Now, I've heard throughout my career, I can't tell you how many times, I will receive a call from an employer and they'll say, you know, Mary has been out on short-term disability leave for the last 6 months and we're not sure when she's coming back. Or Jake is out on workers' comp leave and we're really not sure. We're not getting much clearance. When is he coming back? Now, what's wrong with those two statements? Really the same thing. Those two employees are not on short-term disability or workers' comp leave because there's no such thing. That's an income, those are income replacement benefits that are on the railroad track on the right. They are treatment, they are income replacement benefits. Neither one of those statutes grants employees any leave from work at all. So that leads us to the railroad track on the left. How are you, as the employer, granting this person leave from work? That's the key. That's what you control as the employer. When they're on leave, if they want to seek benefits through the state or through a carrier, that's great. And that's between the employee and that carrier or the state of New Jersey to determine. The most important role of the employer is managing the leave of absence. And that's what we're going to talk about today in the second part of today's program. So, how do we manage a leave of absence? What are the considerations? There are many. We have policy commitments. So your handbook, critical. Your handbook policies play a critical role in managing a leave of absence. That's why your handbook has to be up to date. Your labor agreements, if you have unionized employees, okay? If you look to the purple, to the right of that, your reasonable accommodation process. Well, if the ADA or the New Jersey law against discrimination are involved, as we'll speak of, you have to try to reasonably accommodate that individual. How about statutory entitlements? As you see in the yellow block, Federal Family and Medical Leave Act, the New Jersey Family Leave Act, New Jersey SAFE Act, paid sick leave. And then as you see in the blue square, similarly situated employees. How have we handled these situations in the past? Have we created a precedent for ourselves because of how we handled another employee situation 6 months ago, 2 years ago? And all of that has to be considered when determining how we're going to approve this individual to be absent from work. Now, once we have that determination and we know the reason they're out and how we're going to address it, is there any income replacement benefit available to that employee? And that's what you see here. So if they were injured at work, you're looking at a workers' compensation claim. If they were injured or became ill outside of work, well, they can seek temporary disability benefits. If it's for care of a family member, to care for a child, right, that's going to be the New Jersey Family Leave Insurance benefit. If there's a break in service, now you're looking at unemployment benefits. So depending upon the reason that they're approved to be on leave, there could be a different benefit that that person can apply for. And I hope these first 3 slides really summarize everything that we're going to talk about next really well, and it's something that helps you when your leave issues come up. So let's look at these a little bit further. So what are the key laws here? Well, we got the FMLA, the NJFLA, ADA, LAD, NJ SAFE Act. People refer to it as the alphabet soup, and it very much is. A lot of laws apply. Here's another thing to remember for your remote workforce. If they're working remotely in another state, you have to be mindful of what that state's leave laws are. And do those laws apply to your company? Do you have to have a certain number of employees in that state before they apply to your company? These are things you have to be working with your HR professional on, your outside employment attorney on, to make sure you're complying with every single applicable law. Here's another practice tip. If a remote worker goes on leave and they are approved for a leave of absence, remember, they can't work. They are on leave. So think about it. If just as if they were in the office and now they're on leave and they're no longer here, we can't be assigning them work. The same thing applies with your remote workforce. And it's amazing to me how many employers, that kind of slips their mind because they think, well, the person's home anyway. What's the difference? if they're on leave, they're still at their house. There's a big difference, because if the person is on leave, they can't be expected to work. And actually, if they're on FMLA or NJFLA leave, you're violating their rights by asking them to work while on an authorized leave. So we got to keep that in mind. We have to make sure our supervisors and managers understand that, and they're not picking up the phone or emailing someone who is on an approved leave of absence. So let's delve into each of these leave laws. Now, again, as I mentioned, we can spend, I don't know, 5 hours on each of these laws, right? We don't have that kind of time today. So we're going to hit the highlights, and I want to make some key critical points as to each. Let's first deal with the federal FMLA. What does that stand for? Family and Medical Leave Act. Notice the F, notice the M, and I'm going to come back to why that's important when we talk about New Jersey law. Family F, Medical M, Family and Medical Leave Act. What does that mean? Well, this applies to all private employers with 50 or more employees within a 75-mile radius for each working day during each of 20 or more calendar weeks during this or the prior year. Now, that's important. It's not as soon as you hit 50 employees, this triggers. You have to be at that 50 employee mark for 20 or more work weeks during this year or the preceding calendar year. So you have to monitor your employee count. It's important, especially relative to your handbook. Do you include an FMLA policy or not? Are we over that threshold? Are we not? That's the critical threshold, 50 or more employees within 75 miles for 20 or more calendar weeks. And it also applies to all public agencies, regardless of the number of employees that that agency has. Now, for your remote workers, per the FMLA regulations, the employee's residence is not a work site. It's not a work site. Rather, the work site is the office to which the employee reports and from which assignments are made. So if that work site that the employee reports to or from where the assignments are made has 50 or more employees within a 75-mile radius, the FMLA is going to apply. Very important understanding of the FMLA and how it works, and if it's applicable to your company. So what does this grant, folks? Well, those who are eligible have to be employed with you for 12 months. They have to have worked 1,250 hours in the last 12 months. And as I mentioned, been employed at a work site where the FMLA is applicable. Now, what does this provide your employees? Well, it provides them up to 12 weeks of unpaid leave in a 12-month period. I'm going to come back to that because the state law is different. 12 weeks in a 12-month period. Your paid leave that you provide under company policy, your paid time off, can, under federal law, be run concurrently. And you can establish that by policy in your handbook and say, if you're going to be on FMLA leave, then you would have to utilize your available sick and vacation time. And I'll address that later on in the program as well, as there's a little tweak that we have to know, a little caveat. Okay, what can this leave be taken for? Well, the birth or adoption, foster care of a child, serious health condition of the employee, that's the medical, but also the serious health condition of a family member, which for purposes of the FMLA is the legal spouse, including a same-sex marriage, child, and parent of the employee. Please note, parent-in-law is not covered under the FMLA. It is covered under state law, and I'll circle back to that, but not for purposes of the FMLA. There are also 2 military leave reasons. One, if it's called a qualifying exigency leave, which is something arising out of the fact that the spouse, the child, the parent of an employee is on active duty in the armed forces. And a situation comes up for which leave is requested and may be appropriate. And I've identified those here on the slide. One would be a short notice foreign deployment of that family member. Short notice, meaning you got 7 days or less notice, and it's to a foreign country, not they're sent to training in Atlanta. They're sent to training in California. That's not a foreign deployment. Has to be a foreign deployment with 7 days notice or less. Okay. Military related events. Maybe there's an official ceremony, a welcome home ceremony. They can seek FMLA leave to attend that. Maybe to attend to childcare or school related activities. Maybe while the parent is going to active duty, The other parent will be moving in with his or her parents, maybe in another part of the state, and they're going to have to relocate the child to a different school district. Time off to attend to those matters falls under the FMLA. Financial and legal arrangements. Maybe they want to do some estate planning, will, maybe there's a legal guardianship, those type of things. There's time available for that as well. Rest and recuperation. The service member is coming home. They're going to get a couple of days off for rest and recuperation. There's FMLA time available for the employee as well. Post-deployment activities, and then anything else that's agreed upon by the employer and the employee. Remember, FMLA would be triggered. The other reason would be if that son, spouse, or daughter or parent is injured in the military. The employee can receive up to 26 weeks of leave to care for that ill or injured service member. Okay? Everyone, please make sure you hit mute. I hear someone has their microphone open. Thank you. There are a few unique rules relative to this, and I bullet point them here at the bottom of the screen, so you definitely want to take a look at those as to how you would count the leave when you're caring for a service member. Okay, now, this leave can be taken consecutively, as days in a row. It could be taken intermittently. It could be taken as a reduced work week. Maybe they need 1 or 2 days per week for the next couple of weeks. Perfectly acceptable under the FMLA. They do have job restoration rights when they return to the same or a substantially equivalent position. Now, does the FMLA grant any money? Is this paid leave? Answer is no, right? It's unpaid leave, but of course the employee can always seek an income replacement benefit while they're on leave, and we'll talk about that, whether that's short-term disability or family leave insurance benefits. One thing to note, the employee's health care that's through your group plan remains intact as if the person was actively employed. So if they pay a portion of their premium, they still pay a portion of their premium while on leave, and you're going to want to make that clear to the employee in the leave letter that you give them. Okay. Now, are there any forms that the federal government provides us here to help us manage a leave under the FMLA? Answer is yes. Okay, there are many great forms, and I give you the website at the bottom. It's the Department of Labor's website. And there are a number of forms here, so depending upon the reason for the leave, there's a different form. Now, one that everyone's going to get is called the Notice of Eligibility Rights and Responsibilities. It's a 3-page form that you as the employer must complete. There's different boxes you have to check. I'm sure you're very familiar with this if you're over 50 employees. And you give that to the employee along with the appropriate certification. And I list the different certifications here. They're all accessible on the Department of Labor's website. The employer fills out the top part. The bottom part has to be filled out by the appropriate healthcare professional or by the employee or whatever the reason is supporting the leave request. So my point is, excellent forms are available. Please make sure you're using the ones off the DOL website because they do update them. I know a lot of employers may have them in a file drawer and they've been using the same one for the 5-6 years prior. That's not a good idea. The forms get updated. So whenever you need it, best idea, go online, print it off. You'll know you're using the most updated form. Now, I do have a flow chart here that I put together as to how the FMLA works. And I want to just work through it briefly with everyone. So the employee requests FMLA leave and is going to be absent for 3 or more days and puts the employer on notice. Okay? Let's say that happens. We're going to follow the blue line. Well, now we have to find out, is that employee qualified? Have they been there 12 months? Have they worked at 1250 hours in the last 12 months? Is the FMLA applicable to your business? If yes, we're going to provisionally designate the leave under the FMLA. We're going to write that employee a letter explaining their eligibility for the leave. We're going to enclose the eligibility rights and responsibilities notice. We're going to enclose the appropriate certification, and we're going to provide that to the employee. The employee then has 15 calendar days by law to have that certification filled out and returned. And you can see on the right-hand side of this slide, what happens if none of these requirements are met, right, or are not applicable. And it's a flow chart that's going to walk you through the entire process. But let's stick with on the left-hand side. So the employee then returns that certification. Now we're going to look at it and decide, okay, Is the reason stated one of the reasons eligible under the FMLA to grant this person leave? Is it a medical reason? Is it a family reason? Is it one of the military reasons that we discussed? And we have to analyze under the law whether one of those reasons exists. And I gave you the flow chart here of considerations. Now, if the answer is yes, this is an appropriate request, the documentation is in order, we're now going to provide the employee what's called a designation notice. And we're going to write the employee another letter. And then we're going to say, we received your certification. Everything is in order. Thank you. Here is now your FMLA designation notice approving your leave of absence. And we want to establish the expected return to work date. I help a lot of employers with their leaves of absence. I help them create that written record. And the letters are critical. I always tell our clients when someone's on leave, you're going to be sending them at a minimum 4 letters. At the beginning when they request it, when you give them that certification, when you receive that certification back and you're giving them the designation notice, and then as a reminder, as the return to work date is coming up, you want to remind them of that. You want to remind them that if they're out for their own medical reason, they have to produce a return to work note from their doctor. So it's creating a record, but it's clearly communicating with your employee. And as the title of my program suggests, you are managing the leave of absence. And that's what this is all about, managing the leave of absence. We're not leaving this to happenstance. We're not leaving this to, I don't know when the employee's coming back. I haven't heard from him or her. You as the employer manage the leave of absence. And what this flow chart is going to help you in managing an FMLA leave of absence. Okay, so hopefully that is very helpful. I know you'll have time to digest this when you get the slides. If you have any questions afterwards, you can certainly reach out to me. Let's now shift to the New Jersey Family Leave Act. And what letter do we see that's missing in that title compared to the FMLA? It's the letter M. And what did M stand for? Your own medical condition as the employee. So under New Jersey law, it's only covering a leave for a family-related reason. The New Jersey Family Leave Act. There is no leave under New Jersey law for your own medical condition. So when an issue comes up, we have to understand what's the basis for the requested leave. If it's purely the employee's medical, the NJFLA is off the table. If it's for a family reason, well, now we have to consider if the NJFLA is applicable. And to which employees does this apply? Well, as of February 2019, it became applicable to employers with 30 or more employees. Many of you are saying, wait a minute, I thought it was 50 or more. That was the standard. In 2019, that was reduced to 30 or more employees. Again, look at our time frame during each of 20 or more calendar weeks during the current or the prior year. Okay, this went into effect in 2019. Check your employee handbook. If you have 30 or more employees, you have to have a policy on the NJFLA. If you have less than 30 employees, you're not going to want to have a policy on the NJFLA because it doesn't apply to you, right? So handbook here is critical that we're setting forth the employee's rights and responsibilities in a policy. Very important, especially as to your remote workforce, employees working outside the state of New Jersey are included in your employee count toward that 30 employee count. Very, very important, often overlooked by employers. Okay. Which employees are eligible for this leave? They have to be with you for 12 months. Okay. And they have to work 1,000 hours during that 12-month period. How much time does this give them? It gives them 12 weeks of unpaid leave in a what? 24-month period. Remember, the FMLA is 12 weeks in a 12-month period. This is 12 weeks in a 24-month period. So your record keeping as the employer is critical. A lot of employers are going to keep a spreadsheet. That's a best practice. Keep a spreadsheet. When employees are taking the leave, the dates they took leave. Was the leave under the FMLA? Was the leave under the NJFLA? How many weeks did they use? Because when that employee comes back and requests leave down the road, you're going to want to refer to those records to see, okay, are they even eligible for leave? Have they used all of it? Do they have any time left? And remember these timeframes. They get 12 weeks in a 12-month period under the FMLA. They get 12 weeks in a 24-month period under the NJFLA. So your records are going to be very important to say to that employee, hey, look, you used 8 weeks of your NJFLA last year. So you only have 4 weeks left, okay? If you don't have that record, you're going to forget. And next thing you know, the employee is going to get another 12 weeks when they're really only entitled to 4 in my hypothetical, okay? Can you use their paid time off? Can you require in your policy that their paid time off has to be used while they're on NJFLA? Answer is no. The employee has the right to elect or to elect not to use their paid time off while on NJFLA. Please make sure your policies state that. It's purely left to the employee discretion. Now, what can an employee take NJFLA leave for? I list them here on the screen. Well, to care and bond with a child within 1 year of that birth or adoption, including if that child was born per a written gestational carrier agreement. Please make sure that is in your NJFLA policy. The placement of a child in foster care, the serious health condition of a family member, which includes a child, spouse, parent, parent-in-law. Remember, that's not covered under federal law. It is covered under New Jersey law, as well as a partner in a civil union. Now, you may say, well, what's a family member? I give you the definition here in green. It is very broad. It's a sibling, grandparent, grandchild, domestic partner, any other individual related by blood to that employee, and any other individual that the employee shows has a close association or is the equivalent of a family member. Very, very broad. So let's say you have a neighbor and they're elderly and you've known them for 50 years and you call them aunt and uncle. They're very close to you and that person needs assistance. Maybe they're in the hospital. Maybe they just came home from the hospital and they need your help. They're relying on you and you've known them for 50 years and you have that tight-knit relationship that they are the equivalent of a family member. The employee can request NJFLA leave for that. Your managers and supervisors have to know that. They can't say, what are you talking about, your neighbor? That's not an appropriate request. It's not your real aunt or uncle by blood. It's your neighbor. It's a perfectly legitimate request. And if we don't honor that request, we could be violating that employee's rights. That's why the training of your managers and supervisors on this topic is very, very important. Also added to the law within the last year and a half related to the pandemic is what if the child is home from school? They're homeschooling. Okay? The employee can request NJFLA leave to be home to care for that child when the child is otherwise home from school. Please be mindful of that. So if an employee comes forth and makes that request, we can't say, sorry, there's no such leave available, get back to work. It's an NJFLA perfectly legitimate request. Okay, the leave can be taken consecutively or intermittently. You can also take this on a reduced leave schedule. That is certainly permitted. And the employee just has to provide you with 15 days advance notice of this request. The law used to be 30 days. It's now 15 days as of 2019. Please check your policy to make sure that standard is accurately set forth in your policy. Does this provide the employee any money? No. Remember, we're on Railroad Track 1. This is a leave statute. It's not a money statute. While the employee is on leave, they can go to Railroad Track 2 and they can seek New Jersey Family Leave Insurance benefits through the state of New Jersey. That's where the income replacement benefit would come from. Not here. This is unpaid leave. Do they have job restoration rights? Absolutely. They must generally be returned to the same or substantially equivalent position. Now, we just saw the beautiful forms the federal government gives us to manage the FMLA process. Does the state of New Jersey give you as the employer any forms to manage an NJFLA leave? Answer is no. The employer is left on its own to determine, well, how do we do this? What forms do we use? My suggestion always is, and I help all our clients with appropriate documentation, develop a form that aligns with the regulations that's going to explain the employee's rights and their responsibilities. They're also going to elect how much of their 12 weeks of leave, if they have it all available, they wish to use at this point in time, so that you have a record of how much time that employee is electing. Maybe they only want to use 2 weeks, not all 12 weeks. Have them elect that, have them sign and date, and return it to the person who handles your HR issues. Very important that you have that documentation for your file. Okay? When the employee is requesting foreseeable leave due to a medical condition of a family member, you absolutely can request documentation from that healthcare provider to support the leave request. Great documentation. Again, you're not going to get the help from the state on this. You really need to work with your HR team, your outside employment counsel to develop the appropriate documentation. Now, let's take a look at a couple of things here. The employee has worked 1,000 hours. Are they eligible for the FMLA? Answer is no. They have to work 1,250 hours. Are they eligible for the NJFLA? Yes. So how many weeks do they have available? 12 weeks. Now the employee, let's say, has reached 1,250 hours. FMLA apply? Yes. NJFLA? Yes. So how many weeks do they have? Well, they have 12, but potentially, depending upon the reasons for the leave, they could have 12 and 12. They potentially could have 24 weeks of leave. Another scenario, what about if they need leave for the birth or adoption of a child or the placement of the child in foster care? Yeah, both leaves apply, but it's a total of 12 weeks. Why is that? Because the leaves would run concurrently. The FMLA and the NJFLA run at the same time. And you want to make sure you're communicating that to your employees in writing. So it's a total of 12 weeks. Same thing if they need to care for their spouse or a child or a parent. Both leaves are going to apply, and it's a total of 12 weeks. How about a care of an in-law? Well, we talked about this. The FMLA, not applicable. It doesn't cover parent in-laws. The NJFLA is. So the employee has 24 weeks. You say, well, I don't understand. Why 24 weeks? Well, they get the 12 weeks under the NJFLA, but they still have 12 weeks under the FMLA for a reason that would be covered under the FMLA. So those leaves potentially could line up to give that person 24 weeks. How about caring for yourself? Well, that's just the FMLA, not the NJFLA. So again, they could stack the leaves in a way if they have a reason that would grant them a total of 24 weeks. Military leave, okay, again, yes under the federal law, no under state law. So that too could apply and give them 24 weeks. Same with your military caregiver leave. So let's take a quick hypothetical here. Tom, your employee, was hired 8 months ago and seeks 4 weeks off to care for his wife after surgery, to care for a family member. Does the FMLA apply to Tom? Does the New Jersey family leave apply to Tom? Answer is no. Why? He hasn't worked with you long enough. He's got to be there at least 12 months. So there would be no statutory leave available for him. What would he have to do? Well, he can use his paid sick leave. He can use his vacation time. Right? Maybe you have a policy in your handbook where you grant unpaid leave, but the 2 statutes we've been talking about are not applicable. Now let's go on and see what Tom deals with in his life. After serving a year and 2,080 hours with your company, Tom now seeks 4 weeks to care for his wife. Would the FMLA be applicable now? Yes, it would. He's worked a year and he's worked a number of hours, and the NJFLA would be available as well. So now he's used 4 of his 12 weeks of FMLA and 4 of his 12 weeks of the NJFLA. So he has 8 weeks left under each statute. And as the employer, you want to be sure you're calculating this, you're documenting this, you're writing letters to Tom, you're explaining how you're managing his leave, how much time he's used, how much time he has left. Update your spreadsheet in your computer so that you know how much he has left. Because guess what? 2 months later, here comes Tom again. And Tom is seriously ill and he needs 3 weeks for his own medical condition. Would the FMLA apply? Oh, yes, it would. It's his own medical condition. But the NJFLA is not applicable because it's not for a family reason. So now Tom goes from 8 weeks to 5 weeks on his FMLA, and he still has 8 weeks under his NJFLA. Well, poor Tom, a month later, his father-in-law falls ill and he seeks 4 more weeks of leave. Okay. Now, I realize at this point, your supervisor or Tom's supervisor is pulling his hair out saying, gee, Tom's never here. But does Tom have rights for additional leave? Well, not under the FMLA. Why? It's his father-in-law. Parent-in-laws are not covered. But he does have rights under the FLA. So he still has 5 weeks of FMLA, but he's now down to 4 weeks under the NJFLA. See how important it is to keep these records and to keep this straight and to manage the leaves, because now we have complete control over Tom's leave of absence and his leave rights going forward. So poor Tom, a month later, he suffers personally a relapse. He needs 5 more weeks of leave. Does FMLA apply? Yes, it does. Does the NJFLA apply? No, it doesn't. So now Tom has used the last 5 weeks of his FMLA. He has none left, and he still has 4 weeks under his New Jersey Family Leave Act. And poor Tom, after another 3 weeks, his doctor says, you're not well enough to return to work. You need 3 more weeks of leave, Tom. Uh-oh. Tom's FMLA is exhausted. He has no FMLA. And the NJFLA isn't applicable. It's not a family reason. So now what? Is Tom out of luck? Answer is no. As the employer, we now have to consider leave under the ADA as a form of reasonable workplace accommodation for Tom. The law is very clear that once the FMLA runs out, if the employee still needs some more leave, you have to consider that as the employer as a form of accommodation under the under the ADA. So let's talk briefly about the ADA. It applies to all employers that have 15 or more employees and to all public agencies. It applies to employees who, 1, have an impairment that substantially limits one or more major life activity. There's a record of their impairment because they gave you medical documentation, or the employer regards this employee as having an impairment by the way you treat them, by the way we interact with them, by saying, hey, we understand you're having difficulty with your leg. You broke your leg. We're going to help you. So now we're regarding them as being impaired under the law. Now, prior to 2008, the courts viewed the definition of disability in a very limited way. And the courts, that's where the courts were going with it. And Congress said, that's not where we want this focus to be. We don't want the courts focusing on, is the employee disabled or not? We want the focus to be on, did the employer do what they could do to reasonably accommodate this worker? Did they do everything under their power to engage that employee in the interactive process to try to help this worker? That's what we want the courts to be looking at and examining when these issues come to light. So the ADA can require, as I mentioned, the employee to grant the leave of absence under certain circumstances, and there's no set amount of time for the leave. We just talked about the FMLA and the NJFLA providing 12 weeks of leave each. The ADA does not have any time set. It's what is reasonable without it imposing an undue hardship on the employer. That's the key. So that's why this interactive process between the employee and the employer are critical. How much leave do you need, employee? Let's see the documentation from the doctor. Here are our business needs and requirements and staffing constraints. How much leave can we reasonably provide to you? And after you have that discussion, you want to memorialize it in writing with that employee so that there's clear communication and there's a written record and everybody's on the same page. Okay? That's important. Now, you want to consider using what I call a reasonable accommodation questionnaire. How do you get information from the doctor? Can you pick up the phone and call the doctor and say, Doc, I want to ask you about my employee's situation here. They say they need a leave of absence. No. Absent that employee giving you an authorization, a HIPAA authorization, you can't just call the doctor. So a tool that I utilize with our clients is called a reasonable accommodation questionnaire. It's a 2-page document with specific questions for the doctor to answer. You want to give that document to your employee with a letter. The employee then gives that to their doctor to complete. It goes from the doctor back to the employee, from your employee back to you, because you can't communicate directly with that doctor, right? And once the doctor fills out that questionnaire, it will give you the information that you need as the employer to evaluate the leave request. How much time does this person need? Is there any accommodation that we can offer this worker? And what's the expected return to work date so we can plan accordingly? And it will allow you to then engage in that interactive dialogue or discussion with your employee. Next law to consider, the New Jersey law against discrimination. It applies to all private employers, whether you have one employee or more, the NJFLA applies to you. And the NJFLA could also require you to grant leave to an employee who has a disability. Now, I'm not going to read the words on this slide. I just put it up there to show you how broad the definition of disability is under New Jersey law. It's extremely broad on purpose. Again, the focus is we don't really want to spend too much time drilling down on, is this person disabled under the law? We want to focus on how can the employer accommodate this individual to allow them to perform their job with or without an accommodation, which could include a leave of absence under the NJFLA. So again, employers are required to make reasonable accommodations, and that includes for pregnant employees. Under the law, it's called those who are affected by pregnancy. And it can include not only the pregnancy itself, but childbirth, as well as medical conditions related to the pregnancy or childbirth. And there are examples under the statute, and I list them here in the bullet point for you. Please make sure this language is in your accommodation policy in your handbook. You want to make sure you make it clear to your employees that if you should become pregnant, you have certain protections under the law to certain accommodations, and you want to list them. And you can use this language because it's right out of the statute. Right? Again, the accommodation is to be granted unless it poses an undue hardship upon your company. How much time does the NJFLA provide? There's no set amount of time. Again, it's what is a reasonable amount of time without it creating an undue hardship for the employer. That's where that interactive discussion is going to come into play. Could the LAD require you to extend someone's FMLA leave if they're out for their own medical reason? And we saw in Tom's example, he needs 4 more weeks of leave. FMLA is finished. We're going to accommodate him under the ADA. Do we also have to consider the NJFLA? Yes, because a form of accommodation can be an unpaid leave of absence. We want to communicate this with the employee. We want to engage in a discussion and then have a written letter that explains the individual's leave rights and how you're managing their leave of absence. Does the NJFLA provide the person any pay? No. We're still Railroad Track 1. This is a leave statute. It's not a money statute. Again, the person's on leave for their own reason, health reason, they can go to the state and seek short-term disability benefits. If they're on leave to care for a family member, that's when they would go and seek family leave insurance benefits from the state. We're still here on Railroad Track 1. We're dealing with the various leave statutes when we talk about the NJFLA. We remain on Railroad Track 1 when we talk about the next leave statute, which is the New Jersey SAFE Act. It applies if you have 25 or more employees. It applies to your employees who have been with you 12 months and have worked 1,000 hours during the immediately preceding 12 months. Different standard than what we have been used to and that we discussed with the other statutes. Now, what kind of leave is available to an individual? Well, the NJ SAFE Act essentially protects employees who were the victim of domestic violence or sexual assault, or their family member was such a victim. And the employee needs leave to seek medical attention for their injuries, obtain services from a victim services organization, maybe seek legal assistance or prepare for or attend court, participate in a hearing. So if an employee comes forward and says, this is my scenario, and this is why I need leave, we have to be thinking as managers, the New Jersey SAFE Act would apply if, again, you have at least 25 or more employees in your organization. What is a family member? Again, it's that very broad definition that we spoke of earlier, and it's at the bottom of your slide. Out of the statute, we list here what domestic violence is defined as, and you can see that here bullet pointed on the slide. How much time does it give the employee? It gives them 20 days during a 12-month period following each offense. So God forbid, if an employee is in such a situation and needs this leave, and 3 months later, there's another offense and the person needs additional leave. Okay? Each offense, the employee is entitled to up to 20 working days of leave. It can be taken intermittently, and the employee can elect to use their own available paid time off for this leave. It runs concurrently. So while the New Jersey SAFE Act provides unpaid leave, the employee can elect to use their vacation, or they can elect to use their paid sick leave so that the time off is with pay. Okay. Can you request documentation to support the leave request? Absolutely. And I list here on this slide the type of documentation that you as the employer certainly have the right to request to support the leave. And then, oh my goodness, we have to also consider paid sick leave here in the state of New Jersey. Just a few points here on paid sick leave, because this law went into effect in 2018. I think a lot of employers are very well versed in paid sick leave at this point. I just wanted to throw up a few slides here. Number one, make sure that your company's compliant. There's no small business exemption. It applies to every employer in the state of New Jersey. Also remember, it applies essentially to all employees in your company, not just your full-timers. It applies to full-time, part-time, temporary, seasonal, student workers. I get calls from a lot of employers saying, do my part-timers get paid sick leave? Yes, under New Jersey law, the paid sick leave law, it's applicable to all employees. Does it matter if this employee is exempt or non-exempt as to whether they are entitled to paid sick leave? The answer is no. It applies to all employees. The exempt, non-exempt classification is not applicable or important when you're dealing with paid sick leave. There are only 3 groups of employees that are not entitled to paid sick leave under state law, and that would be those in the construction industry when they have a collective bargaining agreement that provides paid sick leave in it. Per diem healthcare employees who get to decide when they work. They kind of inform the employers when they're available, when they wish to work. Those are per diem employees. And then public employees, if they get sick leave by some other law, rule, or regulation. If you don't fall into one of those 3 categories, you must be providing your employees paid sick leave. And please make sure you have a detailed paid sick leave policy in your handbook. It should cover every aspect of the law, so it shows how you are complying with each aspect of the paid sick leave law. One of the things you want to include in that policy is the reasons that the employee can take leave. And I bullet point them here in the slides for you. It's not just when they're sick. I think everyone at this point is very familiar with the requirements of the law, but it's even to go for diagnosis, treatment, recovery from your own mental or physical illness, injury, or condition, including preventative care. So if an employee were to say, I want to go to a dental cleaning and I'm going 9 o'clock on Tuesday and I wish to use my sick leave, that's a legitimate use of sick leave. It's preventative care. Okay? That's one of the reasons. Diagnosis, care, treatment, recovery for a family member, their preventative care. So supervisor gets a request. Hey, supervisor, I want to bring my mom. She's going for a skin cancer screening and I need to drive her. I need to bring her there. So I wish to use my sick leave. Supervisor needs to understand that's a legitimate request under the paid sick leave law. As I mentioned, to deal with domestic violence or sexual assault, they can apply and use their paid sick leave while on the New Jersey SAFE Act unpaid leave. They can use their sick leave to get paid. If the employee's place of business or the child's school is closed due to the order of a public official, due to a public health emergency, and the employee is home, the employee can use paid sick leave. If a public health official determines the employee or a member of their family could jeopardize the health of others, right? Employee can use paid sick leave. And to attend a school-related conference, meeting, function, or other event, if it's requested or required by the school administrator, teacher, or other professional that that person attend. So is paid sick leave available if the person says, hey, I just want to go to little Johnny's art show? No, that's really not what the statute anticipates. It's, hey, mom, little Johnny's been bad. He's in my office. We need to have a parent-teacher conference. Things of that nature, back to school night, things where it is requested or required by the school that the parents attend. And then again, when we talk about family member, the definition of family member is very broad. It's the same one that I have mentioned here throughout the program, and it includes any employee related, family member related by blood, or anyone who has a close association with that employee, where it's basically the equivalent of a family relationship. Remember, the employees do get 40 hours of paid sick leave. I hear from a lot of employers, they couch this in terms of days. The employee gets 5 days of paid sick leave. Well, that's true if the employee gets 8 hours per day, because remember, they have to get 40 hours of paid sick leave a year. So if you're talking about a part-time employee, part-time employees shouldn't be getting 5 days of paid sick leave, because they may only work 4 hours a day, right? 4 times 5 would be giving them 20 hours of paid sick leave. They need to receive 40 hours of paid sick leave within a benefit year. The benefit year, you as the employer establish, it's a 12-month period. You want to set that forth in your handbook. Could it be any 12-month period? Yes. Could it be the employee's anniversary date of hire? Yes. Can it be the calendar year? Yes. Can it be your fiscal year? Yes. But whatever it is, you want to stick to it. You want to set it forth in your handbook, and you're only going to be able to modify that benefit year if you put the commissioner or the Department of Labor on notice that you're changing your benefit year. And company policies, contracts, and individual employment contracts always have to be considered. Your handbook is critical. I've mentioned the handbook many times throughout today's program. Maybe I do so because I'm so passionate about handbooks. I draft handbooks for our clients. I review their handbooks and give them memos of feedback and help them update it to make sure it's in line with the law, it's in line with their personnel policies and the size of their organization. I do handbooks every day of the week, and your handbook policies are so important. Take, for example, if the FMLA doesn't apply to your business, if the New Jersey Family Leave Act doesn't apply to your business, you have fewer number of employees and those laws don't apply. How are you going to manage an employee's leave of absence? How are you going to comply with the ADA and the New Jersey law against discrimination when the leave issue comes up? You would do it by way of your policy. So I always stress to employers, you definitely want to have an unpaid leave of absence policy in your handbook that would explain if the FMLA doesn't apply or the person has used all their FMLA, but they need leave due to a personal medical reason. This policy now controls to manage your leave. And you would set forth the expectations. You would set forth how you're handling their leave, their health benefits. Do they continue to accrue vacation or sick time while on leave? All that will be spelled out. So when the leave issue arises, there's no guessing game. There's no risk of inconsistent application of how you handle employees' leaves. You go to your handbook and you apply your policy. So handbooks, critical in this regard, as are your labor contracts. If you have any collective bargaining agreements, please make sure you're referring to the employee's leave rights that may be set forth there. And although it's not typical, you may have an employee that has a contract of employment that sets forth certain leave rights that they have negotiated for above and beyond what the law actually requires. So always make sure, especially if you're dealing with an executive level, someone who may have a contract of employment, that you're checking their employment contract as well. Now, in my remaining 4 or 5 minutes here, and then we'll open it up to Q&A, I do want to speak of the income replacement benefits. Now, some of you may be thinking, Mike, you're only going to spend 4 or 5 minutes on income replacement benefits? Yes, that's by design. Remember, you as the employer are responsible for managing that employee's leave. That's railroad track 1. That's why I spent the bulk of our time on that. The income replacement benefit is in some respects, excuse me, out of your hands. In some respects, that's between the employee and the state of New Jersey or the insurance carrier. You will be assisting the employee, you give them the appropriate documentation, and you assist in the process. But with all due respect to all of you and all of your employees, with all due respect, it's really not our concern. Our concern legally as the employer is how do we manage this person's leave? How do we make sure we are securing and properly administering their leave rights, and that we're going to get this person back to work when expected, smoothly? We're going to have a nice, clean written record. Whether they seek benefits while they're on leave, again, I know we're nice people and we hope that they get the benefits, but we don't control that. So again, you saw this slide earlier. They're on a leave. Depending upon the reason for the leave, there may be different benefits available for them. To hit each very quickly, as we know, workers' comp provides your medical treatment and wage replacement benefits for someone who suffered a job-related injury or illness. It's a no-fault insurance program, so no earnings requirement, and it's only a work-related injury. Their job restoration, remember I mentioned this from the start of the program. No, workers' comp is not a leave statute. It's a treatment and money statute. How do we manage the person's leave? Well, if it's their own medical issue, it's going to be either the FMLA, the ADA, the New Jersey Law Against Discrimination, or company policy, or if you have a labor contract. That's what we're going to do to manage their leave. That's what's going to determine if they have leave restoration rights and if they get health benefits during their leave. While they're on that leave, they can seek workers' compensation benefits. Two totally different railroad tracks. Okay, next one. The person has a non-work related injury or illness. Okay. Can they apply for temporary disability benefits through the state of New Jersey? Yes. If your company has a private short-term disability plan, can they apply for benefits through that plan? Sure. Is that your determination as the employer? No. It's going to be up to the state or up to the insurance plan. Your role as employers is just to help the employee facilitate it, make sure they know the benefits available, help them with the documentation. Okay. Now, going back to what I said earlier, Johnny's on short-term disability leave. Correct statement? Again, no, that's a money statute. We as the employer have to control Johnny's leave, whether it's family leave, FMLA, what I meant to say, FMLA, ADA, NJFLA, company policy, or labor contract. That's how we're going to control the person's leave. So does this provide Johnny, our employee, any job restoration rights? No, because it's just money. It's not a leave statute. But if Johnny's on leave per the FMLA, does Johnny have job restoration rights? Well, yeah, as we saw earlier, the FMLA provides Johnny with job restoration rights. So we always have to be mindful, how is this person on leave and what are the laws that apply? Our next benefit, the New Jersey Family Leave Insurance. Employees on leave to care for a family member. Railroad Track 1, you've approved them to be on leave, either under the FMLA, the NJFLA. Can the employee go to the state of New Jersey, fill out an online form, and seek family leave insurance benefits? Yes, the employee can. Do you as the employer make that determination if they get benefits or not? No, you do not. It's up to the state. Do you as the employer fill out some information to facilitate the employee's application for benefits? Sure, you're going to be asked for that information, but that's your role in it. Your focus needs to be, how are we going to manage that employee's leave per Railroad Track 1? So again, if the employee is on an approved leave for one of the reasons provided under the law, FMLA, NJFLA, they can seek the benefits. So this all boils down to where I started. Know which railroad track applies, communicate with your employee his or her rights and responsibilities in writing when the leave is requested, when the leave begins, throughout the leave, and at the end of the leave, so that we can bring that employee back safely and on time to the workplace. So at this point, we're right on time. I love to answer any questions that anyone may have. I know Keith, our moderator, is standing by. Happy to field those questions.
Great. Well, thank you, Michael. Great presentation. A lot of great information in there. So let's get to the questions. And Mike, if you can stop your screen share and I'll
I apologize.
Yeah, no problem. And I'll dig into these questions. So first one, is there a spreadsheet sample you recommend or a standard list or will a standard list suffice?
I guess that means as far as monitoring or tracking employees' leaves of absence?
Yeah, it was around 10:04, so it was during your presentation.
Okay. So no, there's no, you're not going to find anything like on the Department of Labor website or anything. It's basically employer created. I've seen a lot of employers create a spreadsheet and even color code it. So for example, if the employee is on FMLA leave, they color code that in red or whatever color you choose. If they're on NJFLA leave, they'll color code that in green. So it's easier to visualize. But the idea is you want to track it. Now, another thing I want to mention, when you're getting this medical information, the completed certifications, the completed questionnaires, letters from doctors, remember, you're going to be filing that in the employee's medical file, not their personnel file, right? You need to have 2 files for every employee. So good practice, when you're putting that information in their file, go in your spreadsheet, whatever works for you, and make sure we're calculating this, we're setting it forth in the spreadsheet. If you want to color coordinate it, that's great. The key, keeping track of it. I can't tell you how many times, and every time an employer calls me and they'll say, okay, Mike, we have an employee request to leave today. I have to go through a series of questions with them. And one of them is going to be, has this person taken FMLA in the last 12 weeks? And I'm surprised by the number of times I'll get back the question, I don't know, or I don't remember. That's really not acceptable, with all due respect. The employer really should say, let me check the file. I keep a written record, I keep a rolling log. I'll be back to you in 5 minutes. That's important information to have. So whatever system works for you, by all means, have at it.
Okay, great. If we are considering moving from paid sick vacation to a PTO bank of time, anything we should be aware of?
Yeah, great question. So under the law, can you have a PTO, meaning paid time off, all in one policy, in which you provide sick and vacation under one umbrella of PTO? Answer is yes. The law does allow for that. Here is my word of caution, though. Even though that's allowed, my personal preference and what we tell all our clients, I don't necessarily like it. Back in the day, and the day would have been before 2018, it was much easier to have a PTO policy. Lop it all together. It's easier administratively to track everything. But now with the paid sick leave law and all the requirements that fall under that, it's really easier for an employer to have separate policies, a vacation policy and a paid sick leave policy. Why? The law says that every aspect of that paid sick leave law will have to be met. If you have a PTO policy, you would have to bring all those requirements in to control your PTO. Now, that could be quite constraining for some employers. For example, how much time you give them, keeping of the records. What are you going to do at the end of the benefit year? Are you going to cash it out? Are you going to carry it over? How much advance notice you can receive? Under paid sick leave, if it's foreseeable, you can only ask for 7 days advance notice. Well, let's now transpose that to your vacation policy. There's no law on vacation policies. You as the employer set your own policy as to everything. So you can say, we're not going to cash over or carry over or cash out your vacation. We require a month's notice of vacation. We only give you a week of vacation. Whatever you want to set your policy to be, you can do it. But as I said, once you now merge the two and you have vacation and personal sick leave in one PTO policy, you must comply with all the requirements of the paid sick leave law. A lot of employers find that kind of ties their hands a bit and they lose some control relative to vacation. So I can tell you with all the handbooks I work on, I am a big proponent that employers keep these policies separate.
Great. Next one, if an employee works remotely from their home in a different state, but their work is directed from a New Jersey office, which leave law applies?
Great question. Number one, speaking hypothetically in a vacuum, we don't know what state that is and what those state leave laws are in that other state and what the threshold requirements are. So first part of the question would be, the employer definitely has to look into those other states' leave laws, and do they apply to your company? As far as New Jersey, okay, well, where does this employee work? If you're a New Jersey-based employer in Weehawken, and your employee is working remotely in New York City, and you're within a 75-mile radius, okay, the FMLA very much apply if you have 50 employees in a 75-mile radius. Under the NJFLA, it applies. So if you have 30 or more employees total, and you have employees in multiple states, right, as I mentioned on the one slide, all those employees get counted. So that's going to apply. If you have the ADA is a federal law. So if you have 15 or more employees, it's going to apply. So every situation is unique. It depends on what the reason for the leave is, where that employee is located, right? And really what you need to do is work with your HR professional, work with your outside employment attorney to really figure out what laws apply. That's the first thing you got to do. And now that we know what law applies, how does it apply to this particular employee's leave situation? So that's an impossible question to answer in a vacuum, with all due respect, but hopefully that was some of the things checklist items to consider.
If we're using a temp agency, who provides the paid sick time?
The temp agency.
Okay. Can I, as the employer, confer directly with an employee's doctor?
Answer is no. Okay, this comes up a lot. So can you pick up the phone and say, I don't really believe what the employee gave me here. I have questions. Let me call the doctor directly. Answer is you can't do that for a variety of reasons. HIPAA, first and foremost. Okay? And most likely the doctor's not even going to talk to you because the doctor knows of the HIPAA requirements. So what you really want to do is, if you need to speak with that doctor, you have to present your employee with a HIPAA authorization and release document. It's a standard one-page form. It's not a big deal. You probably even find it online. I'm sure your HR professional or outside employment lawyers are very familiar with this. It's a one-page document. You're going to list the doctor, his or her information, what information you're requesting from that doctor, and who the doctor can release that information to. Now, generally, you want it to be whoever handles HR for your company. You don't want it to be the individual supervisor. An individual supervisor or manager should never be speaking with the doctor directly. Never. I don't care if there's a HIPAA release or not. It just shouldn't be. Whoever handles HR. Now, you may say, well, we don't have a formal HR professional at our company. Okay. Whoever handles HR, whoever understands that this information is confidential and how it's to be maintained, is the person that would reach out. Now, one little caveat, FMLA. You give the person the medical certification. They give it to their doctor. The doctor completes it, gives it to the employee. Employee returns it to you. And you're reading the document. And it's chicken scratch. You can't read it. You have no idea what it says. Maybe there's some abbreviations. Half the questions aren't answered. And you need clarification as to what the doctor wrote on the form. Can you call or reach out to that doctor's office for clarification? Yes, the law does provide that. But really all you're doing is saying, hey, doc, can't read what you wrote in line 3. Can you explain what you wrote there and what that means? So you're seeking clarification. You really don't want to go beyond that and start asking about prognosis and so forth without that HIPAA release being in place. So I hope that answers the question.
If the company obtains a worker through a temp agency, is the time that the worker works for my company counted towards the 12 months needed to become eligible for FMLA leave?
That's another great question. Yes, that's a little fine line issue that a lot of employers don't know about. So you hire a temp employee. They're with you for 6 months. Then you bring them on board as a regular employee. They're with you 7 more months. So now we got a total of 13 months. And then they seek FMLA leave. Is that person eligible for FMLA? Have they met the 12-month of work standard? They have. Now, a lot of employers say, well, wait a minute, they've only been here 7 months. No, they've been placed with you 6 months before that. They're there a total of 13 months. So that person would be eligible for FMLA, provided they've also worked 1,280 hours for you in that 12-month period. So that's a great question, very interesting.
And lastly, can my company have a paid time off policy rather than a specific paid sick leave policy?
Yeah, and that's just piggybacks off the question I was asked earlier as to vacation. Same answer I'm going to give. Can you have PTO? You can, but all the caveats that I said earlier, my advice, and I'll tell you what I tell all our clients when we're working on their handbook, it's more efficient for the company administratively to have two separate. Have your vacation policy, have your paid sick leave policy.
Great. So now that concludes the questions. So if anybody wants to do some networking, if you could show your screen, and we can conclude with some networking if we get enough people.
One thing I'll mention, Keith, while we're waiting, if anyone has any questions, comments, and now that we're in the networking session, and I'm sure Danielle or Alice may be mentioning this as well, but we do offer through NJBIA our Employment Law Resource Program. We've been doing that now a number of years. And what that allows is any NJBIA member that may wish to work with us, has employment law concerns, may need help with their handbook, as these personnel issues pop up and need compliance assistance, we're there for them. And we do that on a reduced hourly rate basis as a benefit to our fellow NJBIA members. There is a link on the website for that. There's a little form you can fill out. That form comes to me. Once we run a conflicts check to make sure that there's no conflict and we haven't been opposed to your company in any way, then we can certainly be available of assistance, at those greatly reduced hourly rates. So that's something, again, I thank Alice and Danielle offering our firm to partner with them and with all of you.
Okay, you can find the link to that, as Mike said, on our website under member resources and employment law. And I think, Keith, there was one additional question in the chat. Do you see that one?
Oh, now I see.
Related to a potential fraudulent.
Yes, sorry about that. I see it now. Can you call to confirm a doctor appointment? Had an employee say she went, provide a fake note, phone number, answered phone number like it was the doctor's office. When I Googled the doctor, none of the info matched. I called the doctor's office and they confirmed they had not seen her. No medical diagnosis info, only that they did not see the patient. If not, how do you handle situations where you think someone is fraudulent?
Wow, that's a great question. Certainly a loaded question there. How do we handle that situation? If you're going to call the doctor, in your scenario, if you're going to call the doctor's office, you really want to limit it to, does this doctor even exist? Is this doctor still operational? Is the doctor, well, we know the doctor's retired. This is all fraudulent, to your point. So you want to just find out that you can ask, potentially, is so-and-so a patient at your organization, at your practice? You really don't want to delve at this point into specifics. Number one, the doctor probably won't give you any without a HIPAA release. So I think the next thing you want to do is communicate with that employee and say, look, we got this note. We have questions concerning it. It's legitimacy. So we have some follow-up questions. And I think what you would want to do is present them with a HIPAA release, give them potentially a reasonable accommodation questionnaire that they're them to give to the doctor, and give them a short window in which to return it. Now, if this is fraudulent, as you suggested, you're not going to get anything back, most likely, from that doctor. If you do, all right, and in your mind, the employee may have filled this out him or herself, once you get that HIPAA release signed, then you can call the doctor and confirm. But you don't want to fall prey to a situation where the employee says, hey, wait a minute, you violated my rights under the ADA. You violated my rights in certain situations by calling my doctor, and I never authorized that. And you may feel set up in a way that, well, you left me no choice because I thought this was fraudulent. But there are better ways of creating that written record and explaining your rationale as to what leads you to question this or think there may be something fraudulent going on here. I'm going to leave everyone with this, and not in any way to minimize any leaves at all, but to visualize it. I'm a big visual person, as you could tell with the railroad tracks. I always say to our clients, when someone's on a leave of absence, handle it, manage it as if it's a game of tennis. And I mean that with all due respect. And what I mean by that is that employee hits the ball in your side of the court. I need a leave of absence. Okay, we're going to handle it properly. We're going to prepare a letter, and we're going to hit the ball back into the employee's court. It's now up to that employee to say, okay, I now know what I have to do to get information from my doctor to respond to my employer. I know what my responsibility is. That employee then does that and hits the ball back into the employer's court. The employer now has that information. They're going to analyze it. They're going to talk with their HR professional, their employment counsel. They're going to draft another letter. They're going to hit that ball back into the employee's court. And you always want to do that. And from my perspective, you want to keep that ball in the employee's court, not on your side of the court, because that's when you drop the ball and there's a lawsuit. So it's a game of back and forth. It's communicating. It's making sure the employees know what their rights and responsibilities are, and you are managing the leave of absence. And that was what I wanted to focus on today, is how do we manage that leave of absence, whether it's a remote worker or someone in your workplace.
All right, great. That's all the time we have for questions and networking. So thanks again, Mike. Don't forget, you'll all be receiving a recording of today's presentation and the PowerPoint presentation as well via email. Thanks again, everyone, for joining us. I'm Keith McDonald from Prime Point, and on behalf of Michael Shadiack of Connell Foley, have a great rest of your day.
Thanks, everyone.